बड़े वाले में चॉकलेट रखो। हाँ, बोलते हैं रखते हाँ, अनलॉक करो। चाय समोसा मिला क्या आपको? हेलो, आवाज आ रही? ठीक है। ओ सॉरी, वो माइक कर। हेलो, हो गया? आवाज आ रहा है ना?
Soumya and Sanya, you're requested to start with the orientation.
With every argument sharpened and every team prepared, we now reach the final chapter of this remarkable journey. I, Soumya Chandak, and Sanya Kumari, students of Dr. D.Y. Patil United Societies, Dr. D.Y. Patil Law College, Pimpri, Pune, are honored to welcome you all to the final round of the 4th DYPLC National Moot Court Competition 2025, organized in association with Randive and Randive Associates Pune and Ramkrishna Law Firm and Research Center Chikodi, Karnataka, with knowledge partner Law Octopus Law School, legal tech partner Manupatra, and media partner Law Octopus and Law Bhumi.
Honorable judges, very warm welcome to the fourth Dr. D.Y. Patil Law College National Moot Court Competition organized by Dr. D.Y. Patil Law College. It is an honor to have esteemed panel of judges, Dr. Swarupa Dodam, Registrar Maharashtra for State Human Rights Commission, and our beloved Dr. Anand Randive, sir, Managing Director Randive and Randive Associates. With the permission of the judges, we shall begin the final round. So the stage is set, the stakes are high. Let the final round begin. We have with us DYPLC team code 19 as petitioner and DYPLC team code 09 as respondent.
The participants are requested to turn on their videos. Before we begin, I would just like to clear some things. Each side shall get a maximum time of 45 minutes to present their arguments, of which no speaker shall be permitted to address the court for more than 25 minutes. The time limit is inclusive for the time for rebuttal or sur-rebuttal, respectively. No more than 5 minutes is to be reserved for rebuttal and sur-rebuttal. However, it is mandatory to reserve at least 2 minutes for rebuttal and sur-rebuttal. So, team 0. So team 19, please let us know your reserve time for speaker one and speaker 2.
Uh, so for the DYPLC 19, we are reserving 5 minutes of our time for rebuttal and 22 minutes for the speaker number 1 and the rest 23 minutes for the speaker number 2.
You may take the permission of the judge and you may begin.
Counsel, am I perfectly audible and visible to the bench?
Yes, you are audible.
Much obliged.
Can you-
Your Lordship, may I please the council seek permission to address the bench collectively as your lordships.
Please.
Much obliged, your lordship. Good evening to the bench, court masters, and my learned friend appearing on behalf of the respondents. May I please the court that I am counsel number 1, appearing on behalf of the petitioner in the case of Legal Aid Organization versus the Union of Jambu Deep. Your Lordship, in the present case, I am counsel number 1. I'll be dealing with issue number 1 and 2, and my co-counsel will be dealing with issue number 3 and 4 in the present matter. Your Lordship, for the court's reference, may I proceed with the statement of facts in brief?
Yes, please.
Much obliged, Your Lordship. Your Lordship, in the present case, the victim, who is a minor girl of just 14 years of age, because of her family's financial crisis, she was sent to the state of Bombay for the purpose of employment, where, under the false pretense of securing employment, her brother-in-law sold her to the traffickers, where she was subject to starvation, physical violence, and forced substance abuse. Your Lordship, later on, she was rescued when the police conducted a raid in the hotel room, and from there, she was given a very basic rehabilitation by the state. And later on, when she was sent back to her house, there she faced social stigma, and when she went to school to pursue her education further, she was denied education because of her past. Hence, we are here before this honorable court filing PIL under Article 32, claiming certain rights of the victim which has been violated, and adequate compensation to the victim, as well as to frame appropriate charges against the accused in the present matter before the trial court. If your lordships are well versed with the facts now, may I proceed with the issue number 1? Much obliged, your lordship. Your lordship, before I begin with my issue number 1, I would like to draw the attention of the bench towards one big mistake and the negligence on the part of the respondents. Your Lordship, the respondents have revealed the name of the victim in their memorial which they have submitted to this bench. And Your Lordship, in the case of Nipun Saxena versus Union of India, in Sangeeta Bain Shaileshbhai Datta versus State of Gujarat, and a number of judgments, this honorable court has laid down the guideline that the name of the victim in sexual offences should never be mentioned in any proceeding, Your Lordship. And they have mentioned, so this is a gross violation of this right, and in this way, they are disclosing the identity of the victim. So I'd like to draw the attention of the bench toward that. Starting with my issue number 1, Your Lordship. The issue number 1 is whether the brother-in-law and the other accused individuals, including the brothel owner, can be held liable under the Immoral Traffic Prevention Act and the Bharatiya Nyaya Sanhita. Your Lordship, we are well aware that this issue is not to be dealt by this court, because this court does not have the evidence on record to decide whether they are to be prosecuted or whether they should be convicted under these sections. But what we are praying before this bench is that on the basis of prima facie case before the trial court, the appropriate charges has not been framed. So we are before this bench to make sure that the appropriate charges on the basis of prima facie case, which we will establish right now, on that basis, the Honorable Supreme Court should direct the trial court to frame appropriate charges so that the victim gets appropriate justice, and at the same time, the accused is being punished for the offense which they have committed.
But there is a separate remedy provided for if the charges are not appropriately framed. There is a remedy provided in appellate court. How can it directly come to the Supreme Court?
Your Lordship, this is a step to escape the multiplicity of proceedings, Your Lordship, because victim has already suffered a lot. She cannot go from door to door of the courts.
You are asking the prayer which has to be granted by the appellate court.
Indeed, Your Lordship, we are praying, but Your Lordship, this honorable court being the apex court of the country, they have an infinite jurisdiction. They can pass such orders. And this is just an attempt to make sure that in this PIL only she gets the appropriate justice, instead of going door to door, because your lordship, she has already suffered a lot. Being a child of just a minor age of 14 years, she has already suffered a lot of sufferings. So, lordship, it is my humble prayer before this bench at this stage only, not to increase her sufferings anymore, your lordship, and this prayer to be passed in this petition only.
Public interest litigation will be filed for the those procedural issues. And especially when there can public interest litigation will be filed for these kinds of issues, especially when there is separate provision provided under the procedural law.
Indeed, your lordship, I completely agree with the bench, but your lordship, this case will set a precedent, because your lordship, she is not the only victim in this country of these kind of heinous offenses. We can simply refer from the prop, the second page. Along with the Sujata, there were other victims in the case. So this case will set a precedent for the other matters, your lordship.
That is
So
okay.
it's my that's
But can we take away the jurisdiction of the appellate court when there is a special procedure provided and you are directly come with the under the public interest litigation?
your lordship. This is our humble approach
Because
to this bench.
you are directly asking for the charges are not properly framed. Now, if you are not agree with the judgment or what is the order passed by the lower court, very well you can approach to the appellate court. So there is a procedure provided how public interest litigation is maintained.
Your lordship, this public interest litigation is mainly for the other purposes, which is regarding the compensation, providing adequate rehabilitation. We had just clubbed this one issue with this to avoid the multiplicity of proceedings, your lordship. Because if you go through the rest other two issues, which we'll be dealing further in our arguments, the other three issues are for the benefit of the public at large. It is not just for the victim. We have just added this to make sure that the victim does not suffer. She does not have to go from door to door of the courts, your lordship, because she has already suffered a lot at a minor age of 14 years, your lordship.
That is not a ground that the victim should not be going from door to door because there is a prescribed hierarchy provided by the law. There is no case of going from door to door. There is a procedure. And
Indeed, your lordship.
without following the procedure, you cannot directly jump back to in public interest litigation.
Indeed, your lordship. Indeed, your lordship, I completely agree with the bench on this. But your lordship, in this case, there has been a violation of fundamental rights. If she is not getting proper justice, it will be the violation of fundamental right under Article 21. Right to life and personal liberty shall not get a proper justice, because Article 21 also guarantees right to justice. If she is not getting appropriate justice, it is the violation of fundamental rights. And in that case, your lordship, this honorable court has in n number of judgments held that we can directly approach the Supreme Court, your lordship, in those cases. So it's our humble prayer that this issue to be regarded one such, and the prayer which is being seeked by us to be passed. If your lordship is satisfied, may I proceed with the issue number 1, your lordship?
Yes.
Your lordship, the appropriate sections which we want to be framed is for the brother-in-law of the victim. Your lordship, the charges should have been framed under the Bharatiya Nyaya Sanhita under section 96, which is forcing a minor knowing that she would be subject to illicit intercourse. In this case, the brother-in-law was well aware that if he is selling the victim at a place which is a red light district, we can refer this from the Moot prop, the very first paragraph, last line, your lordship. Selling her into commercial sexual exploitation in one of the Bombay's red light districts, Lal Bazaar. Your lordship, if someone is selling a minor girl at such a place, he cannot take the defense that I have no idea that she will be forced into prostitution. It can be easily inferred from these facts that he was well aware of the fact that she will be subject to forced prostitution and she will be exploited there. She will be forced into to go for the illicit intercourse, your lordship. Moreover,
This argument is otherwise okay in the lower court trial court. We are not in trial court, right?
Indeed, your lordship.
This argument, your argument is there for the conviction or to prevent the charge or to prove the charges. It's okay. We are on a different point. My question is, how if for this particular issue the public interest litigation itself is maintained? Now, whatever you have, knowledge, everything, intention, that is apart. It is there, and that argument is okay with the lower court. We are in a public interest litigation.
Lordship, as I've already presented before this court, the sufferings of the victim, it is just our approach because all the other three issues are for the interest of public at large, for the victims of the exploitation, the victims of the victims of trafficking. This is one issue which is for the interest of. I agree, this is for the interest of only victim, but we are clubbing this because this court has the infinite jurisdiction, and this court is competent enough to pass such order. We know we have skipped one hierarchy of the appellate court. We agree with this. But your lordship, this court has the infinite jurisdiction. This court can grant such order to the trial court to run appropriate trial by framing appropriate charges. This is just our attempt to make sure that the victim does not have to suffer more, like by going to different courts. This is just one issue.
Okay,
And
proceed.
your lordship, and here is the violation of fundamental right if she will not get the justice. So we have rightly approached this court, your lordship.
Sir,
No,
just
moving
wanted to point out that your argument is the individual or the public interest you want from this litigation before the Supreme Court. It is the point of view which sir has proposed you.
Indeed, your lordship.
This study is not for the public interest. Now you can give the sample or a case study. But what you want to achieve with this litigation?
Your ladyship, in this litigation, if we go through the rest three issues is the state should be responsible for any lack in their responsibility to prevent the trafficking activity. This is for the interest of the public at large. The third issue, which is before this bench, is the state has a duty to provide comprehensive rehabilitation and psychological care. This is for the interest of public at large because there are other victims of trafficking and sexual exploitation. So if this court is going to pass regulation today.
See, again, this issue number 3 you are taking on the basis of what is happened with the victim, right? So it is not related to the public at large again.
Your lordship, I agree with the bench, but the factual ground is something different, your lordship, because the victims are not getting appropriate rehabilitation, your lordship.
What are the source? What are the data? So you cannot take one client and saying that the state is not providing. There may be the cases where the state has provided appropriate remedies, right?
Your lordship, in the compendium which we have provided with this bench, in that compendium there is an NHRC report where the court, in the NHRC report, it was like that the victims are not getting proper compensation, the victims are not getting proper rehabilitation, they are still suffering. The rehabilitation being provided by the state are not adequate enough. Only 2% of the victim, there is one victim compensation scheme, but according to that victim compensation scheme, only 2% of the victims are getting that compensation, your lordship. It means it is not at all adequate enough. There is the requirement of changes in those regulations, in those frameworks, legal frameworks. That's why it is needed for the public at large, your lordship. That's why this petition is for the interest of public at large, and it should be regarded as a PIL. Much obliged, your lordship. May I proceed further?
Yes, please.
Much obliged, your lordship. The charges should have also been framed under section 98 because of BNS, Bharatiya Nyaya Sanhita, because it penalizes the sale of child for the purpose of prostitution. And the brother-in-law has committed the same. Furthermore, section 143 clause 1, which is that accused was engaged in trafficking by transferring the victim through fraudulent means. For this, again, I would like to draw the attention of the bench towards the first paragraph of this Moot proposition, the last line. Her brother-in-law handed her over to traffickers under the pretense of securing employment. It means she provided the facts to the victim was something else. He sold her to the traffickers by saying that you are going there for the purpose of employment. But actually, his intention was malified, and he got some consideration by selling the victim. So this is an act which is punishable under section 143 clause 1.
That is the work of the trial court again. Again, you are touching to the scope of the trial court. See, that's what I'm saying. That's what I'm saying. What you are arguing for the prayer before the honorable court is the argument before the lower trial court, right? So, and that you cannot argue this is in public interest litigation. 93 or 143 section, that is the excellent argument before the lower court that too sufficient to prove the case beyond the reasonable doubt, right? In order to convict the actual person. But we are not on that point.
Your Lordship, we are not praying before this court to convict these peoples under these sections. We are just prima facie satisfying this court that whatever act they have done on the basis of the facts mentioned in the Moot proposition, these charges should have been framed, which were not framed by the trial court. And I have already mentioned before this court that to avoid the multiplicity of proceedings and to avoid the sufferings of the victim, we are just clubbing this one issue with this PIL, Your Lordship. Just one issue.
That is covered under writ. How come the public interest litigation?
Your Lordship, this is just to ensure that the victim is getting justice and she is not subject to more sufferings, Your Lordship.
You don't, you will be
Because further three issues have satisfied the court.
In the writs, you will not get the justice.
Your Lordship, indeed we will get, but I have satisfied the court that the other three issues are related to the interest of public at large, Your Lordship. We are just claiming this one issue, which is for the benefit of only victim. But again, Your Lordship, this will be a precedent for the other cases.
Yes,
for the other
proceed.
cases, the victim will have one door open for this honorable court if there is violation of fundamental right, if they are not getting appropriate justice before the trial court.
Yes, proceed.
Much obliged, Your Lordship. Your Lordship, the charges should also have been framed under the Prevention of Children from Sexual Offences Act because the victim was of the age just 14 years. So she is a child under the POCSO Act. So the brother-in-law should have been charged for the abatement of offense of sexual harassment and aggravative sexual assault under Section 9 Clause 5 for aggravative sexual assault and Section 11 for the sexual harassment. She should have been punished under Section 16 for the abatement of this offenses. Moreover, the offense should also be to be framed under the Juvenile Justice Act because the victim was subject to cruelty in the very second paragraph of the Moot proposition, very first page. I'll read the exact line for my lordship. Her captors subjected her to starvation, physical violence, and forced substance abuse, and she endured unimaginable abuse and exploitation. So, your lordship, on these grounds, it means she was subject to cruelty, prima facie. So, Section 75 should have been implicated in this case. Section 81. Section 81 of the JJ Act completely penalizes the sale of any minor child, whatever be the purpose. In this, the purpose was prostitution, which is the most heinous crime, your lordship. So this section should have been attracted in this particular case before the trial court. Moreover, Section 87, again, the liability for the abatement against the brother.
The charges, right?
Apologies, your lordship.
Arguing for paying the additional charges.
Your lordship, there is some issue. I can't hear you.
You are asking for framing additional charges against that accused.
Yes, your lordship, we want you to direct the trial court to frame these additional charges, and then because these charges had not been added, because if we refer to the moot prop of the state, because state is the one which represents the victim, and they have the duty to provide justice to the victim. In their memorial, we can see they haven't framed charges under the Prevention of Children from Sexual Offences and the Juvenile Justice Act. If they haven't mentioned that, means under the charge sheet, those sections are not included. So those charges should have been framed. That's why we are before this bench. Moreover, your lordship, offences under Immoral Traffic Prevention Act, they have framed charges under that. Section 5, which penalizes procuring, inducing, or compelling a person into prostitution. So, your lordship, these are the criminal liabilities of the brother-in-law. Now, I will move further towards the criminal liability of the brothel owner. The brothel owner should have been penalized. The charges should have been framed under Section 99 because he has procured a child for the purpose of prostitution. So the charges should have been framed under Section 99 of BNS. Moreover, under Section 144, Clause 1, which punishes anyone who engages a trafficked child into sexual exploitation. This charge should also to be framed in this case. Again, if we go to the Juvenile Justice Act, the charges should have been framed under Section 75 for the cruelty to the child, Section 77, which penalizes in providing intoxicant to a child. Again, I'll refer to the fact mentioned in the Moot proposition. Your lordship, I seek time extension because only 2 minutes is left with the due permission of the bench. Much obliged, your lordship. The Moot proposition, again, the second paragraph. Her captors subjected her to starvation, physical abuse, and forced substance abuse. It means she was given some sort of intoxicants. Your Lordship, Section 77 should have been framed. The charges should have been framed under Section 77. Moreover, Section 81, which prohibits the sale or procurement of child for any purpose. This section, the offense has been committed under this section. This charge should also have been framed. Moving towards the Prevention of Children from Sexual Harassment Act, Section 9, Clause 5 defines aggravative sexual assault, and it includes coercing a child to consume substance for early sexual maturity. Already provided the facts regarding the same in the Moot proposition. So this charge should have been framed. Moreover, Section 10 provides the imprisonment for Section 9, Clause 5 offense. Section 11, Clause 2 criminalizes the act of brothel owner because he had done the act of sexual harassment, because he forced the victim to show her body to the customers, because he was charging money from the people and was forcing her into the prostitution. And for that, the punishment under Section 12 is mentioned. And the last, Immoral Traffic Prevention Act, under Section 3, which criminalizes managing a brothel. So the brothel owner has managed a brothel. From the facts, it is prima facie established. So charges should have been framed. Section 4, which penalizes living off the earnings of the prostitution. He was living on the earning of the victim. By forcing the victim into the prostitution, he was earning that money. So the charges should have been framed under Section 4. And Section 5, which again penalizes procuring or inducing a child into prostitution. So these are the appropriate charges which should have been framed, and the state has failed. Not the state, the trial court has failed to frame these appropriate charges. So we pray this before this bench that to direct the trial court to frame appropriate charges, and they have again grossly violated the fundamental right of the victim, Your Lordship. Article 23, Clause 1 of the Constitution explicitly prohibits the trafficking in human beings, and in this case, the victim was trafficked. So it is the gross violation of fundamental right of the victim under Article 23. With this, Your Lordship, the counsel for the petitioner concludes its issue number 1. And if Your Lordships has no further question, may I start with the issue number 2?
Yes. What is third one? You are dealing with third also, right?
Apologies, Your Lordship.
You are also dealing with issue number 3, right?
No, Your Lordship. My co-counsel will be dealing with issue number 3 and 4. I'll be dealing with issue number 1 and 2.
What is second issue?
Second issue is whether the police or the local authority in Bombay bear any responsibility for failing to prevent trafficking activities within their jurisdiction.
Do you have any question on that? Do you have any question? But the issue, what issue you have framed?
Your Lordship, in this case, there is a systematic failure on the part of the state to prevent the trafficking activities. They have not taken proactive steps. I'll again say this, proactive steps. Whatever steps has been taken by the state, it were the reactive steps. But Section 23, it is about preventing trafficking activities, Your Lordship. The duty of the state is to prevent. It is not to just, after the victim has been trafficked, they will give the compensation, whatever thing they will do. That is a reactive step, Your Lordship.
But you are saying the three things in your prayer clause. The reactive steps are in your prayer clause. Award a compensation. Because the incident has been happened.
Your Ladyship, the incident has happened. But that's why we have filed a PIL, because there are other victims. Because, Your Ladyship, I would like to draw your attention towards the Moot proposition. Please refer to the second page, the second paragraph. One day during a police raid, if Your Lordships are with me, may I read the same?
Page number?
Page number 2. Page number 2. The second paragraph.
Yes.
Moot proposition. Moot proposition, Your Lordship, not the memorial, Your Lordship.
Okay.
If Your Lordships are with me, may I read that exact line? One day during a police raid at a hotel where Sujata and the other victims were taken for work, she seized an opportunity to escape, while many of the girls hid, accepting their fate. It means, Your Lordship, even all the victims were not rescued from that place. This was the action of the state in this particular case, Your Lordship. Sujata was fortunate enough that she had that courage and she escaped from that place. What about the other victims? They were not rescued. It means the state has failed. the state's machineries has failed in this case, and the state needs to make reforms in their machineries, Your Lordship, so that these things should not happen with any girl in any incoming future. Your Lordship, there has been a failure of the police and the local authorities in preventing trafficking activities. Because, Your Lordship, it is the duty of the state, because if we see the 7th schedule, which is the state list, under that maintaining law and order is under the state list. It means it's the duty of the state to maintain law and order. And in this case, the state has miserably failed to do so. And police is also police is the second article in the not means under the state list. It is the second point that police is the machinery of the state. If the police has failed to perform their duty, it means the state is liable for their failure. And Your Lordship, I would like to cite a precedent of this Honorable Court, in which the Honorable Court in Bandhua Mukti Morcha versus Union of India, it is in my Moot proposition, it is on page number 11. In the Moot memorial, on page number 18, footnote number 10, footnote number 10, Bandhua Mukti Morcha versus Union of India, the Supreme Court affirmed the right to life under Article 21 includes right to live with dignity, free from coercion and exploitation, Your Lordship. In this case, the victim was exploited. So it is the violation of the fundamental right. And if there is the violation of the fundamental right of the victim, it means the state machineries have completely failed. They have failed miserably. Moreover, Your Lordship, I would like to draw attention to the very next case, which is on the very same page, the 10th footnote. Kaushal Kishore versus the state of Uttar Pradesh, where the Supreme Court has reiterated that the state has a positive obligation to protect the rights of the citizen under Article 21, whether the violation is committed by the state functionaries or the private individuals. Your Lordship, just 2 minutes of time extension, I will quickly wrap up this issue because the time has ended.
When I raised the question.
Apologies, Your Lordship. Pardon.
For this case, when I raised the question.
Why we have cited this particular case in the Moot memorial?
No. You would have raised this particular case when I raised several questions regarding how the public interest litigation is maintained. Right? Yes.
Your Lordship, indeed, Your Lordship. Your Lordship, just the time extension because the time has ended.
Yes. Yes, sorry to
please grant time extension. Just 2 minutes of the time extension. I will just quickly wrap up my second issue.
Honorable judges,
permission of honorable
not
bench.
to exceed the time because it also.
Last 1 minute.
Much obliged, Your Lordship. Your Lordship, under this, if they cannot take the defense that the violation of the fundamental right of the victim was because of some private individual, because they are obliged even when the violation has been done by a private individual. Your Lordship, if they are taking the defense that we have formulated different legislations, we have provided adequate rehabilitation and all those things, that should not be considered at all a defense, because on the page number 18, I've cited a precedent of this Honorable Court, Yes Developers versus Harihar Krupa Cooperative Housing Society Limited, footnote number 12. The Honorable Court has emphasized the executive branch's duty is to ensure that the statutes achieve the intended objective. If the intended objective for which any statute was passed, if that is not being achieved, then what is the purpose of formulating all those statutes? It is like similar to that they never existed if we are not achieving the objective for which we have passed that statutes. And in this case, all the Immoral Traffic Prevention Act and all the statutes have failed miserably. The state has not taken any action to prevent the victim. They failed. The whole state machinery failed. That's why the counsel for the petitioner, by resting its issue, will pray before this bench that to consider that the state has failed miserably and they should bear the responsibility for the same. If Your Lordship has no more further question, may my co-counsel proceed with her issues. Much obliged, Your Lordship. It was an honor arguing before this honorable bench.
Am I perfectly audible and visible?
Yes, you are.
Greetings to the bench. If it may please the on.
Please, 1 second. Rest of the participants, please switch on your videos. And yes, speaker 2, as and when you're ready, with the discretion of the judges, you may begin.
Okay. With the permission of the gents, the speaker number two would like to proceed with the argument. Greetings to the bench. If it may please the Honorable Court, this is Counsel 2 and will be taking 15 minutes of the court in dealing with issue number 3 and 4. The third issue that has been brought today in front of this court is whether the state has a duty to provide comprehensive rehabilitation. The contention is proved on three grounds, Your Lordship. Firstly, failure of the state to provide comprehensive rehabilitation due to the loopholes in the present existing legislations. Secondly, inadequate functioning of the juvenile homes and protective homes, and the increased risk of re-trafficking due to the state negligence. And thirdly, denial of the right of education under Article 21A. For the sake of simplicity, the council will be going over each argument individually. Firstly, Your Lordships, violation of Article 21. The petitioners submit that the state has failed in its constitutional duty to provide comprehensive rehabilitation to the victims of human trafficking, as seen in the victim's case, where post-rescue challenges like social stigma, educational denial still very much persist, violating Article 21. Your Lordships, before I begin with my contentions, I have only one simple argument. The state, they claimed in their memorial, firmly claims that they have taken all the rehabilitation measures. The council would like to just ask one simple question to them. Has the state done checkup on the victim after she was sent back home? If no, then the argument fails, Your Lordship, because they have not done the post-rescue rehabilitation measures and not checked up on her after she was sent home. And if yes, they have done so, then why did they not address her denial of school admission? Was it the ignorance of the state, or was it the lack of comprehensive measures? Moreover, Your Lordship, the state has played a passive role as a service provider, like a formality, rather than an active rehabilitation participant, leaving victims like in the present case alone and helpless. Moreover, Your Lordships, the schemes like the Ujwala scheme, the Beti Bachao, Beti Padhao scheme, all these, as they are meant for rehabilitation, however, they lack a structured rehabilitation framework which fails to address the survivor's mental health and reintegration needs. It does not ensure widespread and secure and well equipped shelter homes, leading to poor services, re victimization risk, and ineffective community reintegration. I have, if the time persists, I might have a lot of, I might place before the court a lot of examples, but due to the time constraints, I would just like to emphasize on the Beti Bachao, Beti Padhao scheme that the state have miserably failed in. Your lordships, under the scheme, 5 lakh rupees have been granted to every district. However, I would like to state just one example. In the district of Panipat, 5 lakh rupees have been granted under the scheme. However, 3 lakh rupees were spent on making the entrance of the village for the advertisement of this scheme. Moreover, your lordship, out of the 43 crores that were set aside for the Beti Bachao Beti Padhao scheme, only 5 crores were utilized. It is according to the report of the state, your lordship, the Parliamentary Standing Committee on Human Rights Development. Your lordships, furthermore, all these schemes, they fail to involve survivors in designing their own rehabilitation program, limiting the effectiveness, establishing specialized rehabilitation centers with trauma-equipped programs, including scholarship, job placement, scholarships, and mentorships are essential to breaking the cycle of exploitation and ensuring the survivors' socio-economic empowerment. Your lordships, my second contention is the inadequate functioning of juvenile homes and protective homes leading to re-trafficking. Your lordship, the victims, after they have faced so much trouble, they are sent to these shelter homes. However, the am I audible? The council, am I audible, your lordships? The council states that the state-provided rehabilitation homes function as operative institutions rather than sanctuaries for recovery. Many survivors face post.
Can you use the other network?
Apologies, Your Lordship. Am I audible?
Yeah, now you are.
Your Lordship, the Council for the State provides that the state-provided rehabilitation homes function as oppressive institutions rather than sanctuaries for recovery. Many survivors, they face forced institutionalization in closed facilities, making their experience no different from the brothels that they were rescued from. This contradicts Section 19 and 20 of the Immoral Traffic Prevention Act, Your Lordship, which mandates comprehensive rehabilitation, which the state fails to do so. The Supreme Court in Sampurna Behrua versus Union of India has addressed similar deficiencies in the child care institutions. Yet these failures persist in Bangladesh. Shelter homes, they follow a custodial model where survivors have no say in their rehabilitation. Moreover, Your Lordship, this negligence violates Article 14, Right to Equality, Article 21, Right to Live with Dignity, and Article 23, Prohibition of Trafficking, as well as international obligations under the UNCRC. The Supreme Court in Prajwala versus Union of India has emphasized the need for post-rescue protection. Yet, the state of Bangladesh has failed to ensure education for survivors. Secondly, to prevent the societal stigma, and thirdly, provide vocational training and economic reintegration. Your Lordship, my third contention is the denial of right to education under Article 21A. The petitioner argues that the denial of school admission to victim after her rescue violates her right to education under Article 21A and constitutes institutionalized discrimination, worsening her social exclusion. The Supreme Court in the case of Lakshmikant Pandey versus Union of India and Budhadev Count Maskar versus State of West Bengal have recognized that education is an essential part of rehabilitation that cannot be avoided or that cannot be ignored.
For denial education admission.
Sorry, Your Lordship.
What are the ground for denying her admissions in that institution?
Your Lordship, if we go to the Moot proposition, second page of the Moot proposition, in the last seventh line, it states that she was even denied education in the school because of her past. It was because of the societal stigma that revolved around the victim, because of which her education was denied, Your Lordship. If the state had went for checkups after the rehabilitation was done and after she was sent home from the shelter home of Bombay and Bangladesh, they would have known that the problems that she was facing. They would have done something about it. The fact that no checkups was done in itself proves that there was no rehabilitation and reintegration, because they are acting as it is complementary as a formality for them to do so. They are not very victim centric, Your Lordship. Moreover, Your Lordship, I would like to state a case here. In the state of Rajasthan versus X2, the court has held that whenever a child is subjected to sexual assault, the state or the legal services authority should ensure that the child is provided with the facility of counseling. It will help the victim children to come out of trauma, which will enable them to lead a better life in the future. Moreover, Your Lordship, the state needs to ensure that the children who are the victims of offense continue with their education. It is the judgment of this honorable court, Your Lordship. By failing to ensure the victim-centric educational reintegration, the state has perpetuated marginalization. The petitioner, therefore, seeks judicial intervention to mandate a victim-centric rehabilitation framework and a reabsorption into the education system. The petitioners humbly submit that the state of Bangladesh has failed in its duty to rehabilitate trafficking survivors. Now, with the permission of the bench, the council would like to argue the fourth issue before the bench. The fourth issue that is before the bench today, Your Lordship, is whether victim is entitled to compensation under the Article 21 of the Constitution of India for the violation of her fundamental rights, including the right to life, dignity, and personal liberty. The council would like to present the contentions on four grounds. Firstly, violation of Article 21. Compensation is an appropriate remedy. Any person who has been a victim of human trafficking has the right to compensation, Your Lordships. Compensation entitles the reimbursement of material and immaterial damages that the trafficked person has suffered. Your Lordship, Article 21 of the Indian Constitution guarantees right to life and dignity, and any act that contravenes the same warrants judicial intervention. In the case of Bodhisattva Gautam versus Supra Chakraborty, this honorable court has recognized rape as a crime not against an individual but against society at large, emphasizing its severe psychological and emotional consequences on the survivor. The court has held that rape violates Article 21 of the Constitution, which is the most cherished right, the right to live with dignity, and therefore the survivors must be awarded compensation to aid in their recovery and reintegration before the society. Further, Your Lordship, in the case of Nilabati Behera versus State of Orissa, this honorable court has affirmed that compensation is an appropriate remedy where fundamental rights are violated due to the state's inaction. A similar stance was upheld in Subeh Singh versus State of Haryana, where the court reiterated that monetary compensation serves as a redressal mechanism for the violation of constitutional rights. In the present case, Your Lordship, the victim, a 14-year-old child, has suffered egregious abuse at the hands of the brothel owner, the brothel keeper, her brother-in-law, and many other customers and lustful, greedy men. She was subjected to severe sexual exploitation, depriving her right to live with dignity and denial of the access to education, thereby violating the principles enshrined in the Article 28. The state's failure to prevent her trafficking and inability to ensure her reintegration constitutes a direct violation of fundamental rights. These circumstances establish a clear basis for the grant of compensation as a constitutional remedy. This honorable court has consistently upheld the principle of awarding compensation for the violation of fundamental rights, Your Lordship. The jurisprudence on this subject was evolved through landmark decisions such as Khatri versus State of Bihar, where the Supreme Court has laid the foundation for granting compensation under its jurisdiction. Similarly, Your Lordship, in the case of D.K. Basu versus State of West Bengal, the court has recognized compensation as a public law remedy, stating that it serves not only to redress the victim, but also hold the state accountable for failing in its constitutional duty to protect citizens' rights. Your Lordship, I would like to raise a few loopholes in the schemes before I continue with my issue due to the lack of time. Firstly, Your Lordship, in the schemes like NALSA Compensation Scheme 2018, on which majorly the respondents have relied on as the appropriate remedy for compensation in their memorial, it states a minimum limit for compensation as 1 lakh rupees, Your Lordship. However, the scheme also states that the states have the authority to make their own laws regarding the same. Now, Your Lordship, for as example, a human trafficking victim, a victim in the state of Maharashtra and the state of Rajasthan, both of these victims have suffered the same psychological trauma, the same suffering, the same sexual exploitation. However, Your Lordship, it may happen, and it is actually happening, that the victim in the state of Maharashtra might be provided with a different quantum of compensation than the victim in the state of Rajasthan. Why I'm stating the state of Rajasthan specifically is because, Your Lordship, the state of Rajasthan has ruled that the maximum amount of compensation under the NALSA compensation scheme to be 1 lakh rupees, which is ironic because that is considered, that is stated as the minimum quantum of compensation under the scheme. Moreover, Your Lordship, the scheme also emphasizes that the monetary compensation must be paid and that the total compensation has to be paid within 60 days that is 2 months after the case has been closed. However, Your Lordships, according to NHRC report, it has been found that the 70% of the victims, you can also refer to the compendium, Your Lordships. The report it's there in the compendium, that 70% of the victims, they receive the quantum of compensation after 1 to 2 years, and the rest 30% of the victims, they have received the compensation after 2 to 3 years, Your Lordship. These are all the loopholes which we can go on further stating. However, I would like to draw the court's attention that the legislation that the state, they keep on making this legislation on the board, Your Lordship. It's present in the books, on the paper. However, its implementation, which is also the duty of the state, is it on the grassroots level. It is lacking, Your Lordship. Considering the vastness of this country, we do not have appropriate implementation of all these legislations and schemes. Moreover, Your Lordship, in the case of Yash Developers,
You mean to say that this court should give direction to the central government or the state government to have a unified compensation system?
Your Lordship, we pray that this court suggests the state to make mandatory statutory legislations and to recorrect all the loopholes that are present in the constitutional in the schemes that they have been implementing right now. Your Lordship, for this, I would also like to state in the case of Nipun Saxena, along with the other rehabilitation and integration rules, Your Lordship. Moreover, I would also like to state the NALSA compensation scheme to 2018. It has been created in the case of Nipun Saxena. That case, Your Lordship, it was stated by the state, on page number 7 and 8 of the judgment, that they are making amendments in the POSCO Act, and it is only till then that this scheme to be regulated for the union, because there was no other compensation scheme present at that time. However, after 2018, most of the states, they have failed to make the necessary changes in their compensation schemes according in regulation with this NALSA scheme, and this scheme has also not been corrected or amended from then. If the judges are satisfied, may the council proceed with the arguments?
Yes.
Indeed, Your Lordship. Your Lordship, additionally, in Delhi Domestic Working Women's Forum versus Union of India, the Honorable Court has directed the government to provide compensation, rehabilitation, and medical assistance to the survivors of sexual violence, recognizing the need for comprehensive victim support mechanism. Apart from the constitutional remedies, Your Lordship, statutory provisions also mandate compensation for the victims. Therefore, it is submitted that the victim in the present case is entitled to adequate compensation for the violation of fundamental rights. The state's failure to prevent her trafficking, protect her dignity, and facilitate her rehabilitation constitutes a grave violation of the duty, warranting judicial intervention in the form of monetary compensation. My second contention, Your Lordship, is the inadequacies in the compensation.
Counsel, are you asking the compensation only for the victim?
Your Lordship, the council is asking compensation for the victim, and along with that, to make a statutory victim compensation tribunal which can monitor and oversee the compensation, the providing of the compensation to all the other victims of human trafficking as well, and to correct the loopholes in the present legislation. Your Lordship, the counsel for the petitioner submits that in the existing compensation mechanism for victims of human trafficking and sexual assault, they are inadequate and fails to provide an effective remedy for the fundamental rights violation. Your Lordship, the NALSA compensation scheme lays down 13 factors for determining compensation. However, when most of the victims, they approach the legal district authority for the same, they are denied. And also, Your Lordship, under this scheme, the guardians of the victims, they cannot go to the district authority and claim for the compensation. It is only the victim or the parents of the victim that has to do so. But there's a loophole here that most of the victims of these cases, they are minors, and almost half of them, according to the state themselves, are pushed into trafficking by their parents due to the financial crisis. Therefore, it makes for a very ignorant policy as whole for the survivors, and not very victim-centric also, Your Lordship. Your Lordship, the evolution of Vishaka guidelines into POSH Act 2013 highlights the necessity of a legally binding framework for victim compensation, and not just rules and recommendations, ensuring automatic and mandatory relief. Under Article 21 of the Constitution, the state has a duty to protect individuals from trafficking and sexual exploitation. Your Lordship, in the case of Abdul Rasid versus State of Orissa, the Orissa High Court has held that it is the state's responsibility. It does not end with prosecution, but also extends to ensure victim rehabilitation and compensation. Expanding Article 21, the courts have affirmed that compensation must be granted even when private individuals commit crimes, as also reaffirmed by my co-counsel in the issue number 2. My third and last contention in the present case, Your Lordship, is the need for a dedicated human trafficking compensation tribunal. The current legal process for victim compensation is complex, bureaucratic, and slow. And even for the interim compensation, the victim has to go through a long litigation process. The issue remains the same, Your Lordships. The issue regarding the rehabilitation of the victim remains the same because in the meanwhile, the victim has no support from the government and the state, and she has to go through social and financial hardships at the same time. A specialized compensation tribunal should be created to handle trafficking victim compensation claims. It should have automatic and immediate financial relief provisions, a fast track process to ensure timely relief, and victim centric procedures to prevent the re victimization and the re traumatization of the victim. Your Lordship, compensation and reparation for victims, they are not, it can be hugely significant in providing financial security to reduce vulnerability. Moreover, the state cannot deny its duty and obligation by stating that they are trying to do so or that it is a slow process. Your Lordship, it is the mighty state after all. They have all the resources. The state is not there only for the political gains. It also has to protect its citizens. It is its duty. Compensation and recuperation is essential in providing acknowledgement to the harm that the survivors have faced and in some circumstances in contributing to the punishment of survivors, punishment of traffickers, Your Lordship. We meant to make sure that whatever victim has suffered, no other girl in this country has to suffer the same, Your Lordships. Moreover, compensation will not only protect the victim in the present, but also make sure of her career and education in the future. The fact that the respondents in their memorial are not even stating that they have failed in their duty to provide her education. Her career is gone, Your Lordship, if the schools are not addressing her, if the schools are not admitting her. She is just a child. She has a right to pursue her education under Article 21A. If the state has done its duty effectively and adequately, she wouldn't have to come up in this forum right now. The fact that we are here discussing this case right now in itself proves that the state has not fulfilled its duty and has ran away from its obligation to provide compensation. Your Lordship, if the Lordships do not have any further questions, the counsel for the petitioner would like to proceed with the prayer. Your Lordship, before the council begins with the prayer, the council requests to make a change in the first prayer if the bench permits.
My question was, you want to make a change or you want to continue with the first prayer?
Your Lordship, we want to make a change in the first prayer. If the bench, with the permission of the bench.
Okay, then we'll decide.
Okay, Your Lordship. Apologies for the same, Your Lordship. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the counsel for the petitioner humbly prayed that this honorable court may be pleased to adjudge and declare that, firstly, to direct the trial court to frame appropriate charges and expedite the trial process. Secondly, hold the state liable for their failure to maintain law and order and to prevent trafficking within their jurisdiction. Thirdly, to direct central government to ensure the right to education under Article 21A of the victims of sexual offences is not being violated due to social stigmas. Fourthly, to direct the central government to constitute a dedicated tribunal to deal with matters regarding compensation to the victims of human trafficking, which must include, firstly, fast-track process to ensure timely relief. Secondly, victim-sensitive procedures to prevent re-traumatization. And thirdly, automatic and immediate financial provisions. The fifth prayer would be, Your Lordship, to award appropriate compensation to the petitioner for the violation of fundamental rights, including Article 21 of the Constitution, including interim compensation and any other relief, including monetary compensation if required in the future. And lastly, to issue necessary guidelines and policy recommendations to strengthen the legal framework and enforcement mechanisms against human trafficking, and or pass any other order, direction, or release that this honorable court may deem fit in the interest of justice, equity, and good conscience. And for this act of kindness, the petitioner, as in duty bound, shall humbly pray. It was an honor pleading in front of you, your lordships.
Can you pray the prayer of amended prayer before we speak? And again, the same question which I raised to your partner, that what is your prayer that direct the trial court to have a fair trial?
Your lordship, the first prayer is to direct the trial court to frame appropriate charges and expedite the trial process. That was the change we were intending to make.
That can be again done in if your application is rejected by the trial court. Very well, you can find the appeal or any other recourse that the procedural court point, right? How can you pray against this in the public interest case?
Your lordship, I'm unable to hear the question properly. If you may please repeat.
What you pray that you asking the direction to the trial court that you claim proper issue. So it means that you are not satisfied with the whatever the issue claimed by the trial court, right?
Yes, your lordship.
What is the remedy as per the procedural law if the issues are not properly claimed?
Your lordship, however, according to the other three issues, this issue has just been attached in this petition. Mere on the ground of clerical error, victims should not be deprived of any appropriate remedy. That is why we are present here before the honorable bench and requesting this change.
Okay.
It was an honor pleading in front of the bench, your lordships.
Thank you, team 19. With the discretion of the judges, counsels representing respondent, we'd like to know your reserved time for both the speakers.
Courtmaster, I am the first counsel on behalf of the respondent, and I shall be addressing this honorable bench for a total time period of 20 minutes. And my co-counsel shall be addressing this honorable bench for a total time period of 20 minutes. And we reserve 5 minutes for sir remarks.
With the discretion of the judges,
You may begin.
You may begin.
Just to confirm, am I properly audible and visible?
Yes.
Much obliged. Much obliged, your lordships and your ladyship. A very good evening. The council requests to address your ladyship and your lordships collectively as the bench.
Yes.
Much obliged. 4 pertinent issues that have been framed under this PIL petition that shall be argued on behalf of the respondents before this honorable bench. First, whether the brother-in-law and the other accused individuals, including the brothel owner, can be held liable under the Immoral Traffic Prevention Act of 1956, which is the ITPA, and the Bharatiya Nyaya Sanhita of 2023, which is the BNF. Second, whether the police or local authorities in Bombay bear any responsibility for failing to prevent trafficking activities in their jurisdiction. Third, whether the state has a duty to provide comprehensive rehabilitation, psychological care, and reintegration programs for trafficking survivors, including social sensitization initiatives to combat stigma. Fourth, whether Sujata is entitled to compensation under Article 21 of the Constitution of India and relevant statutory schemes for the violation of her fundamental rights, including the right to life, dignity, and personal liberty. I shall be dealing with the first 2 issues, while my co-counsel shall be dealing with the latter 2 issues. If there are no preliminary inquiries, your lordships and your ladyship, I request the bench to allow me to proceed with the first issue.
Yes, please.
Much obliged. Under the first issue, your lordship, as has already been pointed out by your lordship previously, I shall first establish that the present petition is not maintainable to the extent of prosecution. And then I shall establish that the state has provided the victims adequate legal framework for the prosecution of the accused. It is submitted to this honorable bench that courts should exercise great care and caution while allowing PIL petitions, which are public interest litigation petitions. The requirements for a PIL petition have been laid down in several cases. For instance, in Joginder Singh versus the state of Punjab, where the court should be satisfied that there is substantial public interest involved. Therefore, PIL petitions are only maintainable to the extent of addressing larger public interest. Further, the court on a previous occasion has refrained from delving into prosecution proceedings due to separate criminal proceedings, such as in the landmark ruling of this honorable court in the case of Vishakha versus State of Rajasthan. A PIL petition is not of an adversary character, but for the performance of constitutional duty. It gives the opportunity for the lawyers, the judiciary, and the state to come together to make the human rights more meaningful for the disadvantaged sections of the society. Furthermore, Your Lordship and Your Ladyship, the court has therefore declined the PIL petition in the case of State of Jharkhand versus Shiv Shankar Sharma, stating that they will not initiate investigation as that is the job of investigating agencies. If the petitioners want, then they can basically accumulate all the evidence, present it to the investigating agencies, and then the investigating agencies can decide whether they should proceed with the investigation or not. And therefore, the petitioner should approach the appropriate forum for those proceedings. The court definitely.
It's not only they are not satisfied with the conviction or the charges made. They are asking some things which is beyond the trial court jurisdiction, right? Especially issue number 3 and 4. So in that case, how will you justify that public interest litigation is not maintainable only because one of the issues cannot be dealt by this court?
I'm sorry, Your Lordship. If I may restate my submission is not that this entire petition is not maintainable. The submission under the first issue is that this PIL petition is not maintainable till the extent of prosecution, which means that only prosecution proceedings should not be initiated in this particular forum. As long as issues 2, 3, and 4 are concerned, we shall be making submissions on behalf of the state under those issues. And that can be dealt with by this honorable bench.
Okay.
If you're satisfied with the answer, I shall proceed with my submission.
Yes.
Your Lordship, therefore, this court may have the power to intervene in an investigation if there are issues with that investigation and a petition is made to this court. However, the initiation of an investigation or prosecution is not something that should be dealt with in a PIL petition. If Your Lordships and Your Ladyship are satisfied with the submission under my first submission, then I shall request the bench to allow me to proceed with the second submission.
Please.
Much obliged, Your Lordship. The second sub-issue simply establishes that the present legislative framework, Your Lordships and Your Ladyship, under the ITPA, which is the Immoral Traffic Prevention Act, and the Bharatiya Nyaya Sanhita, which is the BNS, is sufficient to determine the liability of the accused individuals. Therefore, first, this Honorable Supreme Court had noted in the case of Delhi administration versus Ram Singh that the ITPA is a complete code to deal with the suppression of immoral traffic in women and girls. It shall therefore not require the aid of any other external material. If I may quickly walk this honorable bench through the scheme of the ITPA and the BNS as well. Section 2A defines a brothel and Section 2 subclause F defines prostitution. Section 3 intends to hit at persons who establish and maintain brothels or assist in the management thereof. Your Lordships and Your Ladyship, thereafter, Section 4 punishes a person for living on the earnings of a prostitute. And to establish this, it should be proved that the accused knowingly lived on the earnings of prostitution. Section 5 then makes it punishable to procure a person for the purpose of prostitution. Section 6 makes it punishable to hold someone in detention in a premises where prostitution is carried out. Section 7 makes it punishable to carry out prostitution in the vicinity of public places with a caveat of 200 meters. And Section 9 makes it punishable for a person who has authority over another person to abet their seduction of this particular person for the purpose of prostitution. Yes, Your Lordship.
Appellant, they don't have any problem regarding what is there in the books. Rather, their argument is law is good in books, but not in for the implementation. Their main contention is that provisions are there is a proper provision, but state is not properly implementing, especially the criminal procedures and the procedural laws, what they have challenged. Secondly, the compensation. Now, what law you are read, again, they said it is there, but implementation is not there.
Your Lordship, the issue regarding adequate compensation and whether that is being implemented shall be dealt with under the fourth issue by my co-counsel. As far as the first issue is concerned, the only burden on the state under the first issue was to establish that whether the accused individuals can be prosecuted under the ITPA and the BNS or not, which means that whether it is possible to prosecute them or not. The submission on behalf of the state is that it is definitely possible for them, since the entire scheme of both of these legislations have specific provisions to address the specific concerns that have been raised by the councils on behalf of the petitioners. And therefore, we do not require any new legislation or any further changes in the legislation, and there has been no prayer regarding that as well under the first issue by the councils on behalf of the petitioners.
Yes.
If that satisfies the query of your lordship, I may proceed with my submission. I shall quickly go over the provisions of the BNS as well. Your lordship, as rightly pointed out by you, there are provisions in addition to the ITPA, which are section 96, which makes it punishable for someone to induce a child to go from any place with the intent or knowledge that they shall be induced into illicit sexual intercourse. Section 98 makes it punishable to sell, and Section 99 makes it punishable to buy or hire someone with the intent of using them for prostitution or any other immoral purpose. Section 143 thereafter defines the offense of trafficking itself. In the present case, as I stated in the answer to your query, your lordship, it is alleged that the brother-in-law of Sujata had authority over her and he handed her over to the traffickers. Furthermore, there is also an alleged involvement of the brothel owner and the captives of Sujata, who held her captive in an alleged brothel and forced her into commercial sexual exploitation. Therefore, as stated, the present provisions under the ITPA and the BLS give ample opportunity to the petitioners to approach the appropriate forum and initiate prosecution proceedings in that appropriate forum under the present legal framework. If the bench has no further queries, I rest the submissions under the first issue, and I request the bench to allow me to proceed with my submissions under the second issue.
Yes, please.
Indeed, much obliged, your lordship. Your lordship, under the second issue, it is submitted on behalf of the respondents that the police and local authorities have fulfilled their legislative mandate on dealing with the issue of trafficking, and that they do not undertake any additional liability. The word liability should be focused on, as that has been repeatedly used by counsels on behalf of the petitioners for the trafficking activities going on in their jurisdiction. Your lordships and your ladyship, the courts have previously noted that adequate efforts by police and local authorities invested to deal with trafficking cases portray a fulfillment of their duties, irrespective of the results that are achieved. This was stated in the case of Santosh Rai versus the state of Punjab. Your lordships, furthermore, section 13 of the ITPA requires appointment of a special police officer and a non-official advisory body. Under section 15, the police can search a premises without a warrant if they have reasonable grounds to believe that an offense under the Act has been committed. Now, your lordships and your ladyship, it was held in the case of Syed Abdul Khair versus State of Maharashtra that section 15 subclause 4 and section 16 subclause 1, those are basically concerned with the removal of young girls from the brothel, cannot be held as unconstitutional. It is further recommended that to deal with the menace of trafficking, the police should conduct raids, it should rescue the victims of trafficking, and conduct the search of the premises. Your lordships and your ladyship, with respect to the functions of the magistrate under section 17A of the ITPA, they must satisfy themselves on the genuineness of the parents, guardians, or the husband that they hand over the victims to. Therefore, the delay that has been there, it is basically the magistrate carrying out their duties under section 17A. Now, they can also take actions under section 18 for the closure of a brothel and the eviction of the offenders from that brothel. Dear lordships and your ladyship, it is therefore established that the police have certain specified legislative duties that they have to mandatorily perform that have been laid down under the scheme of the ITPA. Now, carrying out the raid at the hotel, rescuing Sujata, and arresting the accused individuals clearly showed that these duties laid in the legislative framework have been fulfilled as has been laid down in the aforementioned section. Is there a query on behalf of the
No, but the fact shows that you are rescuing only Sujata. There are others girls also for which no action is taken by the police officer. What do you say? That is what the other argument from the other sides.
For that particular regard, there are reports to suggest that there are statistics on both sides to suggest that the police have in fact taken adequate steps. And then there are reports on how the conviction rates might be low in certain trafficking cases. However, it is important to state here that in various previous cases, such as the Vishaljeet case, the Gaurav Jain case, the courts have in fact lauded the efforts of the police and the local authorities and stated that they have in fact invested a lot of efforts in eradicating the issue of human trafficking itself. The second notation that the court has done in further cases is that the issue of human trafficking is not something that can only be dealt by local authorities and the police. It is a broader societal issue which needs to have holistic and societal solutions. However, when we strictly concern ourselves to what this issue requires, it is to state that whether existence of trafficking activities entail a legal liability of the local authorities or the police. That our submission on behalf of the state, your lordships and your ladyship, is that there is no legal liability in that under the issue that has been framed by this particular court. If the court wants to give certain directions like it has in previous occasions, for example, provision of helpline numbers to victims and NGOs, or setting up anti-human trafficking units even at the village level, because that is where trafficking happens at the grassroots level. These kind of units work at the district and state level right now. Then the police and the local authorities will happily be work with the state and the judiciary to see to it that those directions are carried out. And therefore, our entire effort under this PIL is to address the issue of human trafficking. However, if we confine ourselves to the limit of this issue, there is no liability and there is no legal backing to ascertain any liability of the police or local authorities under this issue.
Yeah.
If that satisfies the query of your lordship, I shall again cite another example of a landmark ruling of this honorable court in the case of Vishaljeet versus Union of India, where a very similar prayer, your lordship and your ladyship, had come up, where the petitioners had basically asked for a CBI inquiry for the police and the local authorities, stating that there are ongoing trafficking activities and therefore these authorities should be held liable for these ongoing trafficking activities, in fact, throughout the country. The court had categorically denied this particular prayer for the petitioners, stating that a CBI inquiry or affixing any kind of legal liability upon the petitioners, upon the police or the local authorities would not result in anything. And again, as I stated, they had noted in their obiter dicta that trafficking is a broader societal issue, and rather than affixing liability of the local authorities or the police, we must work in tandem with them.
That judgment is in respect of transferring the investigation from the ordinary police to the CBI, right? Judgment which you are referring.
Yes, your lordship.
In the power of the court transferring the investigation from the ordinary court to the CBI.
Your lordship, if I may remember the judgment correctly, the prayer was in fact regarding launching an investigation for the purpose of ascertaining legal liability of the police officers and the local authorities, and the court had denied that prayer, stating that such an inquiry or such an investigation to ascertain legal liability is not maintainable. What we can definitely do is issue directions to them, and they can comply with those directions. They can file status reports. They can file reports of the number of FIRs that have been filed and the ones that have been disposed of. Those are the kind of directions that we are happily ready to comply with. However, while ascertaining legal liability, that is something that should not be done by this. That is our position, Your Lordship. Your Lordship, if that satisfies your query, I shall conclude the submissions under the second issue as well. That, as the courts have stated, holistic societal solutions are required for eradicating trafficking activities. But as I stated, there can be no additional responsibility placed on the police or local authorities of Bombay for the persisting trafficking activities. If there are no other inquiries on behalf of your ladyship and your lordship, I conclude my submissions under issue 2 as well, and rest my case and invite my co-counsel to present our submissions under issues 3 and 4. Indeed, it was a pleasure arguing before you.
Am I perfectly visible and audible?
Yes.
Thank you, Counsel. I'm the co-counsel for the respondent, and today I will be addressing issues 3 and 4 over the next 20 minutes. If my lordships and my ladyship have no preliminary questions, I request to move forward with my submissions for issue 3.
Hey, you can proceed.
Much obliged. My lordship, my ladyship, the third issue at hand today before this honorable court is whether the state has a duty to provide comprehensive rehabilitation, psychological care, and social reintegration programs along with sensitization initiatives. My lordships and my ladyship, the submissions of the council are threefold in the matter. First, that the state has taken all efforts according to constitutional mandate and international commitments. Two, that the statutory framework, and three, the non-statutory framework are adequate to address the concerns of the victims and rehabilitate them. My lordships and my ladyship, Article 21 of the Constitution guarantees a right to life. This includes a right to live with dignity, good mental and physical health, and most importantly for this case, autonomy over one's sexual choices. Article 23 guarantees a right against exploitation. This also includes a right against sexual trafficking. My lordships, it is in line of this that the state of Jambudweep has pledged its duty to several international conventions. I thank the opposing counsel for mentioning a few of them. However, the respondent would like to bring to the notice of the court that in addition to the International Convention of Rights of Child, the Palermo Protocol, the Convention on Elimination of Discrimination Against Women, Jambudweep has also ratified the Convention for Suppression of Traffic in Persons and Exploitation of Prostitution and Others in 1951. In fact, it is in line with this convention that the Immoral Traffic Prevention Act of 1956 was enacted. My lords, my ladyship, Section 21 of the ITPA provide for the establishment of protective homes. Moreover, Section 17A was added to this act via an amendment of 1986. It requires that when the victim is to be released into the custody of a guardian or a parent, the court must satisfy itself that that parent or guardian is indeed capable of taking care of that child. This, my lords and my ladyship, was done with the intention to prevent re-trafficking of the victims by the family members itself. Moreover, my lords and my ladyship, the petitioners have contended that there is an inadequate framework, that there is a loophole of framework to provide rehabilitation of the victims. The contention of this, my lords, the argument of the respondent is that it's not true. My lords, the Protection of Child Against Sexual Offences Act was enacted in 2012 along with the POCSO rules of 2020. Rule 3 clearly mentions that the state or the central government, as the case may be, must tailor-make educational material for children to make them aware of their rights. These must also be advertised using the media. Rule 6 requires medical aid and care to be protected to minor victims of sexual assault. Rule 4 requires the training of officials who deal with children and also the NGO officials who interact with these victims. Moreover, my lordship and my ladyship, the Juvenile Justice Act, Care and Protection of Children, was enacted in 2015. In fact, this legislation has an entire chapter 7, for the rehabilitation and social reintegration of children in need of protection and care. Section 39 clearly mentions that this approach is taken via an individual care plan that is required to be tailor-made to the conditions of each victim and each child in the need of care and protection. My lord, moreover, Section 27 requires the formation of a Child Welfare Committee. My lord, the petitioners elaborately explained the loopholes of the NALSA scheme, and they contended that it is inadequate in providing rehabilitation and that in this particular case, rehabilitation has not been provided. However, my lordship...
They have one query also. That's there on the point that of course, what you have left for the law and the legal position, of course, it is there. But those provisions are not inadequate to fulfill the requirement of the society. And that is what they have prayed in prayer number 3. that they declare that the state is failed to maintain the law and order in the society. So that's why they pray for the additional provisions. What do you want to say? We'll come to the compensation aspect later on.
Absolutely, my lordship. My lordship, I was coming to that point itself. They have contended that the state has failed in taking measures to combat or rehabilitate victims. However, the council would like to bring to the notice of this court that the Ministry of Home Affairs has established several anti-human trafficking units across the country. They aim to prevent, prosecute, and protect victims of human trafficking. As of today, there are 696 functioning AHTUs countrywide. Secondly, my lordship, apart from the NALSA scheme that provides legal aid and social sensitization and stigma-related programs for victims, the Ministry of Women and Child Development have also enacted the Mission Vatsalya scheme of 2022. It mainly focuses on residential care and education to children and women in need of protection via their child care institutions. Lastly, or moreover, my lordships, the petitioners have submitted to this court of the failure or the elaborate failure of the Ujjwala scheme. My lordships, it's important to note that the Ujjwala scheme is no longer in existence. In fact, in 2019, the scheme was merged with the Shakti Sadan scheme. The Shakti Sadan scheme establishes homes and also aids in the initial documentation of victims and also in FIR filing. To this date, there are 445 functioning Shakti Sadan homes countrywide. Moreover, my lordship, another contention that the council would like to bring in front of this honorable court is that the council has made conjectures about the implementational problems, the statistics, and they have given the NHRC report as part of an authority. However, this report is absent in their memorial submissions. My lordships, these are the submissions on behalf of the respondent state, and based on the elaborate schemes, not just statutory but also the non-statutory schemes and the efforts taken by the government, the respondent would like to contend to this honorable court or submit to this honorable court that there exists a holistic framework that is capable and sufficient in itself to provide rehabilitation, psychological care, and social reintegration programs to the victims of human trafficking. If my lords have no further questions on this issue, the council would like to move on to the next issue dealing with compensation.
What issue, please?
Absolutely, my lordships, much obliged. My lordships, the last and the final issue before this honorable court is whether Sujata is entitled to compensation under Article 21 of the Constitution for violation of her fundamental rights and the relevant statutory schemes. My lordships, the first submission that the council would request to make before this court is that in their prayers, the councils have repeatedly said that they have approached this honorable court via public interest litigation for reformation for Sujata, a singular victim. My lords, no doubt, Article 32 empowers this honorable court to provide compensation to victims who have suffered a violation of fundamental rights. However, under this issue, it is the humble submission of the court that there exists a statutory framework that enables and empowers courts to provide compensation to victims, and two, that today, at this stage, this court is not the appropriate forum for Sujata to seek compensation, and she must approach the appropriate forum to seek compensation in the matter. My lord, Article 32 is a provision that empowers this court to grant compensation when there is a gross patent violation of fundamental rights. Likewise, there are schemes existing in the legislative framework, specifically Section 395 and 396 of the Bharatiya Nyaya Suraksha Samhita 2023. Section 395 provides for compensation to be awarded to the victim from the penalty that is imposed on the accused. If that is deemed to be inadequate, the courts can then turn to Section 396, under which a victim compensation scheme has been established. It requires that all state governments establish their victim compensation schemes under which compensation can be given from the state. My lord, it is important to note that the POCSO rules of 2020 also use this victim compensation fund under Rule 9 to compensate victims, minor victims of sexual crimes. My lord, no doubt.
Pay for
Yes.
any kind of compensation only for Sujata.
Sorry, my lord, I was unable to hear the question.
The other side has not claimed any kind of compensation specifically for Sujata. If you go their prayer, they are asking for certain reforms and again changes in the law, right? And asking for the increasement of compensation. Yeah? They are not come with the specifically with the Sujata's case.
Certainly, my lord. My lord, the council requests the court for another 2 minutes to give some context, and I will address this point in particular.
51 minutes, please.
Much obliged, my lord. My lord, no doubt Article 32 empowers this court to provide compensation. However, there is enough sufficient and efficient schemes in the legislative framework, specifically the 396 of the BNSS, the POCSO Rule 9. My lord, in this case, there is no reform as such required. The procedure under these laws are quite clear. My lord, there is an existence of a victim compensation scheme. In case of a minor victim, the special court, using the POCSO rules of 2020, Rule 9 to be specific, will use this victim compensation scheme and ascertain the amount of compensation to be provided based on 12 elements which are present in Rule 9 itself. Moreover, it is the duty of the State Legal Services Authority and the District Legal Services Authority to ascertain the amount of compensation that is to be provided after an order by the magistrate is passed. The contention in the present case, my lord, is that in fact, in the case, my lord, is the cases that were presented by the petitioners itself clearly mention that the courts have to be privy to the facts and circumstances of the case before awarding compensation. The cases of D.K. Basu that were mentioned by the petitioner categorically hold this. In addition to that, my lord, in the judgment of Ankush Shivaji Gaikwad versus State of Maharashtra, this honorable court has held that the court must be privy to the facts and circumstances of the case. They have to ascertain whether the compensation ought to be provided. In other words, the court has to put its mind to the facts and circumstances of the case in order to adjudge whether a victim is entitled to compensation or not. My lord, the argument of the petitioner stand null because in this case, excuse me, my lord, in this case, it is the trial court or the special court that is equipped to deal with the facts, to accept evidence, to accept the witness list, in fact, adjudge the matter and convict the accused and then consequently pass an order of compensation for victims of human trafficking. My lord, the state is absolutely not denying that victims of human trafficking deserve compensation. In fact, in advisory passed by the Ministry of Home Affairs, the minimum compensation to be provided is 1 lakh rupees. There have been cases as well where even rape victims have been given compensation of close to 8 lakh rupees by the State Legal Services Authority. Therefore, my lord, it is the humble request of the respondents to that this honorable court direct the petitioners to approach the appropriate forum under the relevant adequate legislative framework in order to seek compensation.
Yes.
The council hopes that this has addressed the concerns and the queries raised by the honorable bench.
Yes.
Thank you very much, my lord. My lord, this essentially brings me to the end of my submissions. In fact, to conclude, the petitioner has mentioned in one of their reforms the creation of a victim compensation tribunal. It goes contrary to their own submissions that there is already a lot of confusion regarding the procedure established under the particular framework. Adding another judicial body, adding another executive body, a tribunal will only complicate matters further. My lord, the reason there is a victim compensation scheme as an umbrella where multiple legislations can use it in order to provide victim compensation is done for this very reason, my lord. Therefore, it is the request of of the council that this honorable court reject this submission or recommendation of reform to create a victim compensation tribunal. My lord, this brings me to the end of my submission. The council requests to move ahead with the prayer of the respondents.
Yes, please.
Much obliged. In light of the submissions made, the question raised before this honorable court, it is the humble prayer of the respondents that this honorable court find, adjudge, and declare that this petition is non-maintainable to the extent of prosecution of the accused, and direct the petitioner to approach the appropriate forum for prosecuting the accused individuals under the present legislative framework of the ITPA and the BNS 2023, which are completely adequate for such prosecution. Number two, that the police and the local authorities in Bombay have fulfilled their legislative mandate of duties and they bear no additional responsibility for the persisting trafficking activities in their jurisdiction. Third, that the current legislative, both statutory and non-statutory framework of the state entails all adequate measures to provide comprehensive rehabilitation, psychological care, and reintegration programs for trafficking survivors, including social sensitization. Four, that the petitioner ought to approach the appropriate forum under the relevant laws before approaching this honorable court under Article 32 read with for the violation of fundamental rights, or request this court to pass any order, decree, or judgment in light of justice, equity, and good conscience. The counsels on behalf of the respondents rest their submissions. It was an honor arguing before this court.
With the permission of the bench, we may begin with the rebuttal round.
Yes, please. How many minutes?
Am I audible to the bench, Your Lordship?
Yes.
Much obliged, Your Lordship. Lordship, before I start with my rebuttal, I would like to answer to the two questions which they have raised in their arguments. The first one was they have made an allegation that we have not mentioned the NHRC guidelines, which we have stated in our arguments. But Your Lordship, the compendium which we have submitted with the Moot Court Society, there we have given that NHRC guideline. It was there in the compendium.
It's there.
It's there. And the second thing is, again, in the prayer, they have saying that this petition is not maintainable to the extent of prosecution. But Your Lordship, this bench is well aware that we have never prayed for the prosecution. We have just to direct the trial court to frame adequate charges. We are not before this court to pray that the accused to be prosecuted. We are not for that purpose before this bench. Starting with my rebuttal, Your Lordship, as they have as already pointed out by the counsel for the petitioner that they have mentioned the name of the victim in their written arguments. Again, they have mentioned the same in their oral arguments, Your Lordship. I just point out this thing. Moreover, they are saying that the police has performed their duties. Different duties they have mentioned under the different statutes. But Your Lordship, I would also like to draw the attention towards one duty of the state under Section 168 of Bharatiya Nagrik Suraksha Sanhita. Section 168, Your Lordship. If I may read for Your Lordships, is every police officer may interpose for the purpose of preventing and shall to the best of his ability prevent the commission of any cognizable offense. What about this duty, Your Lordship? They have failed to perform this duty. So how they can say that the state has not at all failed in performing their duties? Moreover, Your Lordship, they have mentioned n number of international guidelines that they have ratified this international treaty, that international treaty. They have performed, they have formulated different statutes, different compensation schemes, this, that. But Your Lordship, all this has been signed by the political leaders. They were in their formal attires. They endorsed the international legislation within the confinement of the luxurious state chambers. But reality on the ground is starkly contrast with these lofty commitments, highlighting a significant disconnect between the policy and the actual practice.
That is the only process we have till today, right?
Indeed, Your Lordship.
Right?
Your
That
Lordship,
is the
if
only
you may
process.
permit. Apologies, Your Lordship.
That is the only process we have, that all these international treaties have to be signed by the political people.
Your Lordship, all these international treaties has been signed They have formulated the laws according to that, but on ground, they are not at all effective. They are not adequate enough. They are not enough to prevent, they are not even to achieve the objective for which it was formulated. For this, Your Lordship, if Your Lordship may permit, I would like to quote two proverbs, which is in Hindi, Your Lordship. If Your Lordship permit, in Hindi. Much obliged, Your Lordship. The first one is, हाथी के दांत खाने के और दिखाने के और. Same is these all statutes. Your Lordship, a bit time extension. I'll just quickly wrap up.
Conclude your.
Much obliged, Your Lordship. I'll just quickly wrap up. In this case, they have formulated these n number of provisions and statutes, but in reality, they are of no use. And the second is, Unchi Dukan Fika Pakwan. They are showing, they are boosting before this bench that we have done this, we have done that, but the ground reality is, I'll show you one data of the Maharashtra government. In the Maharashtra government, Your Lordship, there has been a drastic decrease in the funding. Here they are saying we are doing this, that for the victims, for the women, but there has been a drastic decrease of 69%, Your Lordship, in Women Counseling Center. There has been the biggest funds cutting. How the state will answer to this, Your Lordship? Your Lordship, they have also completely ignored the educational right of the victim. The victim also the victim has approached this court with also one prayer, which they have completely ignored, that she is not getting admission in the schools. What about this, Your Lordship? They have completely failed to consider this thing, Your Lordship. Your Lordship, with this, the counsel for the petitioner rests its rebuttal. It was an honor to appear before this bench. Much obliged, Your Lordship.
Permission of the bench, may I proceed with my rebuttal?
Yes.
Much obliged, Your Lordship. My Lordship, since the rebuttals have reached to the procedural issues of this very competition, let me remind that the councils on behalf of the petitioners, that it was written that the oral arguments have to be strictly restricted to what has been submitted in the written memorial. The compendium does not form a part of the written memorial, and therefore a report that is a part of the compendium and not the written memorial is something that is not allowed to be submitted in their oral arguments before this honorable bench. Second, the Moot proposition does not talk about any framing of charges or any criminal case that has or any criminal suit that has been initiated by the petitioners on behalf on behalf of the victim in any lower court. Clarification number 10 that had been issued by the MCC clearly states that any facts cannot be assumed, and the participants have to clearly adhere to the facts that have been provided in the proposition. If the proposition is silent on framing of any charges, what charges are the counsels on behalf of the petitioner seeking to amend? The third contention, as has been raised by the counsels on behalf of the petitioners regarding using the name Sujata in the oral arguments, the counsels on behalf of the respondents seek to submit that the exact guidelines by this honorable court is that the name of the victim should not be used in such cases for their disclosure to the public. And if there is an issue with the usage of the name in the written arguments and the oral submissions, the counsels on behalf of the respondents profusely apologize. But we would like to state that this entire session is being recorded. The counsels on behalf of the petitioners have used that name again and again themselves in the oral arguments. So if there has to be any penalization or any rebukement that on to the counsels, it has to be on both sides. Furthermore, we have talked about how there is an endorsement of international legislation, but there is no practical implementation. There is no basis to that. This is plain conjecture that has been provided and as pointed out by your lordship himself. That is the procedure that is followed for implementing national legislation. The final statistic that has been provided by the counsels on behalf of the petitioners is regarding statistics of the state of Maharashtra. However, your lordships, the Moot proposition clearly states that the laws are pari materia to India. It does not state that Bangladesh is a state whose laws are also pari materia to any particular state. Therefore, any statistics with regard to any Indian state are not relevant to the argument presented before this honorable bench. With that, addressing all the rebuttals that have been levied by the counsels on behalf of the petitioners, we humbly submit as the rebuttals. It was again a pleasure arguing before this bench.
Thank you.
Okay. Thank you, teams. So, as we come to the conclusion of this intense and thought-provoking final round, I would like to ask the judges for their feedback to the teams.
I just have one feedback to the team one. Your complete memorandum is silent about the quantifying the compensation. It's an important one, and you had missed. About team two, you are at the respondent side. I mean, you get quite well. Of the loser side, I guess. That is only the feedback. Quantification of the compensation is necessary while making any prayer or a memorandum, as per the fact of the situation of the state, as well as the victim case. Thank you.
Thank you, ma'am. Sir.
Okay.
Okay.
That's all.
Okay. So before,
Okay.
shall I?
That's all.
That's all from both of us.
Thank you. So before we all leave, I, Nivedita, your court master, would like to take this opportunity to express our heartfelt gratitude. First and foremost, I would like to extend our sincere appreciation to both the finalist teams for their outstanding performances. You guys have truly set a high standard, making this final round a remarkable one. Regardless of the results, you have demonstrated exceptional skill, passion, and sportsmanship. A special and profound thanks to our esteemed panel of judges whose expertise and keen insights have been invaluable in evaluating this competition. We are deeply grateful for your presence and guidance. With that, we extend our best wishes to all the teams and we look forward to celebrating the results soon. Thank you. I would request the teams to now leave the meeting and wait for further instructions.
Thank you so much.
With that, we'll take a break for 20 minutes and announce the results. The judges are requested to submit their score sheets. Thank you.
With due respect of the principal, sir, and esteemed guests, should we start?
Yes. Anjali, you can start. Mike.
You can start now. You can start. Proceed further. Can you hear me? Can you hear me? No. You can start
Yes,
now.
sir.
Yes, you can start now. You can start now. Actually, not audible. Am I audible? Vijayta ma'am? Yes, sir.
I request all participants, please on your camera.
Are you audible, ma'am?
I request all participants, please on your camera. Dear participants, please on your cameras.
Can you hear?
I request all participants, please on your cameras.
You just click on the arrow. Just click on the arrow.
Vijayta ma'am, are we audible?
फोन निकालो ना
वहां पे वो जो साउंड है वहां पे वॉल्यूम बढ़ा दो
हम मोबाइल बंद कर दीजिए
तो वहां पे जो साउंड है वहां पे ऑटोमेटिक ये बढ़ा दो वॉइस बढ़ा दो कॉर्नर में रहते
उन्होंने म्यूट किया ना स्पीकर वॉइस
Speaker.
मैम ने खुद म्यूट किया है मैम ने म्यूट किया है हाँ It's okay. It's okay. It's okay.
Settings working. Too much better.
Yeah, it's getting. The green signal. Yeah.
Vijayta ma'am, please unmute yourself.
Vijayta ma'am, can you hear me?
येतोय ना पण?
Vijayta ma'am, can you hear me?
Yes, she can hear it.
सर आवाज जातोय तो कमी येतोय आवाज आपला.
Yes, sir.
Can you hear me?
Yes, yes.
Proceed. Go ahead. Go ahead.
स्पीकर काम नहीं है.
Speaker हमारी
नहीं तुम बोलो बस.
A very good evening, everyone. I, Anjali Rai of BLLB 4th year, the co-convener. And Shreya Kanse of BLLB 4th year, the student coordinator. It gives us immense pleasure to welcome you all to the valedictory function of the 4th DYPLC Moot Court Competition, National Level 2025, organized by Dr. D.Y. Patil United Societies, Dr. D.Y. Patil Law College, Pimpri, Pune, in association with Randive and Randive Associates, Pune, and Ramakrishna Law Firm and Research Center, Chikori, Karnataka. The legal tech partner Manpatra and media partner Loctopus and Law Bhumi, with knowledge partner Loctopus Law School. Our esteemed institution, Dr. D.Y. Patil Law College, established in 2001, is one of the most distinguished law colleges affiliated with Savitribai Phule Pune University. Our institution has been beacon of legal education, nurturing young legal minds and promoting academic excellence since its inception. With a vision to impart quality education, the college has been engaging students in various academic and extracurricular activities. Today, we gather here to mark the successful completion of the 4 DYPLC Moot Court competition national level. This year, we are thrilled to announce that we had around 30 teams across India who participated with immense enthusiasm, dedication, and zeal. The competition witnessed a remarkable advocacy skill, legal acumen, and an extraordinary display of a courtroom argument, making it a grand success. Now it's time to welcome our esteemed guest for today's valedictory function. It is an honor to have with us Dr. Swarupa Ma'am, Registrar of Maharashtra State Human Rights Commission, and Advocate Anantarandive sir. We extend a warm welcome to both of you. We now invite our respected principal, Dr. S.S. Gopakumar sir, for the welcome address.
Honorable Chief Guest, Saripa Dolama, and Honorable Advocate Anand Randive sir, esteemed faculty members, students, and dear participants. It is with great pride and honor I extend a warm welcome to all to the valedictory function of 4th National DYPLC National Moot Court Competition. Indeed, it involves a hard work and dedication by our faculty members, students, and obviously participants that make this event a successful one. In fact, I appreciate the efforts which has been taken by each and everyone, because if I look upon the efforts which have been taken, it has started in the month of November, and we plan to have this competition in the month of December. Due to certain technical reason, it has been extended to till March end. So I appreciate the coordinators. They have been following up very aspects of this competition and coordinating with the judges, various judges, and their time schedules, and various law colleges all over India. Last year we had more than 58 teams who participated for competition. This time, obviously, we have 26 participants. Since the reason is that it has been delayed, that is the reason why there were number of participants are less. Even then, in the beginning, what we thought is that the last round, 2 rounds, will be conducted offline. But due to the inconvenience of participants, we have decided to organize this moot court in online, in full-fledged. And furthermore, there are a lot of efforts which has been taken by Dr. Patil Law College in order to inculcate the advocacy skills upon the students. And further extend by organizing such kind of moot court competitions by which advocacy skill can be inculcated upon each and every student who pursue the law. As and when you appear before a court of law, you should not be surprised by the procedure which is to be followed before the court. Obviously, in moot courts, we don't follow the procedure. We are trained to argue before the court. Obviously, will be conducted. We are having a plan for our students from the next semester itself. And furthermore, I appreciate the winners and I congratulate the winners of this moot court competition. The result will be announced shortly. But the important aspect which is required to be remembered is that in a competition, we have to select 1 or 2 persons as the winner. But each and every student, every participant, whatever the efforts which have been taken, it will never go away. It will be helpful in any extent when you start your practice. So don't dishearten that you are not the winner of this final. Because the legal profession where which you continuously have to update, and whatever the knowledge which you learn, and it will be remain with you one or other circumstance where which it will help you to help what we can say to utilize it for assisting your clients. And furthermore, Today we are fortunate enough to have a honorable registrar of State Human Rights Commission. Completed a PhD, and the PhD subject, which is what we can say, that's a cornerstone, and it is a reference book for the research scholars. And we are fortunate enough to have such a wonderful personality, Swarupa ma'am, and I welcome ma'am on behalf of Dr. D.Y. Patil Law College, and on behalf of management, and on behalf of all faculty members, and on behalf of all our students, and also Anand does not need introduction, and he trained our students also for the moot court competitions and class moot courts and everything. I welcome Anand Reddy sir also, and he is also one of the sponsors of this moot court competition. So it is indeed a great privilege to each and every participant of this moot court competition for the Dr. D.Y. Patil National Moot Court Competition. And I appreciate you all for your hard work, dedication, everything that makes this event as a successful one, and that culminates in this position. And I also welcome all the participants, and I will also welcome all the staff members, and also I welcome all the students. So it is indeed a happy moment as far as me is concerned, because the day one of this college, I am the and this year our students successfully participated more than 12 moot court competitions, and they won many prizes also. So indeed, as a moot court coordinator and as a principal, I really happy about today's event. And I am not extending. Thank you very much. One more thing I'll tell you, things will not happen in a fine morning. The wheels started rolling a long back. Each and every individual who was behind this, each and everyone's contribution. I remember each and every participant. I appreciate each and every winner of this competition, and I wish you all the best. I'm sure that each and everyone participant in the moot court, they will have a mark. They will put a mark on legal. Either be practice, or it may be or wherever it may be. So I wish you all the best. Thank you very much for giving me an opportunity for addressing you in this occasion, and I extend my heartfelt thanks to our coordinator Vijay Chaudhary ma'am, coordinator Deepali Shitole ma'am, and all other faculty members who contribute for successful culmination of this program. And thank you very much. And it is requested to announce the result. Would I have? Okay, so the result will be announced shortly. I conclude myself, and I welcome once again. Thank you very much.
Thank you so much, sir, for your kind words and warm welcome. Now, to introduce our esteemed guest, Dr. Swarupa Nolam Ma'am, Registrar, Maharashtra State Human Rights Commission, and Advocate Anant Randive, sir, we invite Assistant Professor Samruddhi Shah ma'am.
Thank you, Anjali. It is my immense pleasure to introduce our today's chief guest for valedictory session of 4th DYPLC Moot Court Competition National Level 2025, Dr. Swarupa Narayan Dholam. Dr. Swarupa is a seasoned legal professional, academician, and researcher with over 2 decades of multifaceted experience in judiciary, legal administration, and academia. Currently holding the prestigious position of Registrar at Maharashtra State Human Rights Commission, she leads the legal and research wings of the Commission. Her responsibilities encompasses overseeing complaint registration, conducting impactful legal research, organizing training and awareness programs, and coordinating with educational institutions and NGOs. In academia, Dr. Dholam has been visiting lecturer in criminology and a master trainer in judicial computing systems. training over 150 judges in advanced technologies such as Linux OS and Central Information Systems. She is a published author of books on prisoner reformation and cyber law and has contributed extensively to national and international research through papers on live-in relationships, electronic evidence, and cyber law. As a professional, her blend of legal acumen, research excellence, and dedication to public service continues to make a profound impact on the legal human rights landscape in India. We welcome you, ma'am. Now, I would like to introduce our another guest for today's valedictory session, Advocate Anant Randive, sir. Advocate Anant Shivaji Randive is an experienced and respected legal professional with over 17 years of practice in civil, criminal, revenue, and consumer courts. He holds a master in LLM with a specialization in corporate and criminal law from Pune University and Bachelor of Law from ILS College, Pune. He is standing advocate for Pune Municipal Corporation, Maha Metro Rail Corporation, and Pimpri Chinchwad Municipal Corporation. Additionally, Advocate Randive is a member of the Maharashtra State Advisory Committee under the PCPNDT Act. His firm, Randive and Randive Associates, represents several well-known clients, including Wagmare Promoters, Nirmiti Constructions, DVS Technocept Private Limited, and more. It's our immense pleasure to have you with us, sir. So I welcome all of the judges for the today's valedictory session. Thank you.
Thank you, ma'am. We now request our principal, Dr. S.S. Gopakumar sir, to facilitate Dr. Swarupa ma'am, Registrar of MSHRC. We now request esteemed guest Dr. Swarupa Dholam ma'am kindly address and share her words with us.
Thank you, Principal Sir Gopal Kumar, Advocate Randive, Vijita Madam, Lakshman Sir, all the faculty members and dear students. Thanks for the taking the subject which is never be taken into the moot court competition. Always I have seen the constitution is there or any other criminal law is there, but the NHRC's advisories, human rights commission's executive to human rights commission has been taken by colleges to the moot court competition. So I acknowledge all of the principal and his team for taking this subject as a moot court competition. First of all, I will acknowledge all the students for their efforts in this. In our time, it was like the moot court competition was only for the gaining of the marks. It was not a competition just we have. If it could have been there in our time, then we could have been the best lawyer also sometimes. I feel so. The preparation, the presentation skills, what you have at here, it's really recommendable. Another acknowledgement is for the Randive and Associates because less advocate firms are contributing to the social entrepreneurship, I can say so. Normally, lawyers are stigmatized to only but not contributing it to the society and to create a healthy fraternity. It is important for the lawyers also who are moving ahead into the society to give a hand to the student and to come, let them come ahead. So this is my short submission about this Moot competition.
Thank you so much, ma'am, for your inspiring words. Moving ahead, we now invite Advocate Randive sir to address the participants.
Moving on, as we know that we are already late, but all the participants who are participating. See, as sir has rightly said, that the whoever who had participated in this competition they are the winners. See, one or two students are the basic motto for taking this all multiple competitions that when you start the practice, you should be ready with all these materials. Like what kind of you are done, what you're discussing with ma'am also, that the students are very participate, those who are winner, those who are not winner for us only.
Thank you, sir, for your valuable insight and words of encouragement. Now, to formally express our gratitude and declare the results, we invite Assistant Professor Dr. Vijita Chaudhary ma'am for the vote of thanks and result declaration.
Before proceeding that,
Thanks, Anjali and Shreya.
before proceeding that, what?
Sorry.
Can you proceed, Shreya?
हमें सुनाई नहीं दे रहा ना आवाज करो नहीं आवाज करेंगे तो यहाँ पे
Yeah.
We apologize for the mistake we have done. We now request our principal, Dr. S.S. Gopakumar sir, to facilitate Advocate Ananta Randive sir. Now, to formally express our gratitude and declare the result, we invite Assistant Professor Dr. Vijita Chaudhary ma'am for the vote of thanks and result declaration.
Thanks, Anjali and Shreya. So first of all, good evening, everyone on the dais.
My dear faculties, dear students, and dear participants, once again, good evening. Myself, Dr. Vijeta Chaudhary, at Dr. DY Patil Law College, it is my honor and privilege to stand before you today as we are concluding the fourth National DY Patil Moot Court Competition. This prestigious event brought together some of the brightest legal minds from across the nation, showcasing extraordinary advocacy, legal wisdom, unwavering dedication, and knowledge. Before I proceed to announce the winners, I would like to extend my heartfelt appreciation to all the participants for their commendable efforts. Each round was a true reflection of the spirit of law and justice. I would also like to express my gratitude to our esteemed judges, faculty members, student volunteers, and management who made this event a grand success. Now, without any further delay, it is my immense pleasure to announce the winners of the fourth DYPLC National Moot Court Competition. So, first of all, I start with the Best Researcher Award. So, the Best Researcher Award goes to DYPLC team number 11, GLC Mumbai. Congratulations. And the prize money is 5,000 rupees. Now, I'm going to announce Best Memorial Award. The Best Memorial Award goes to DYPLC code 07 KIIT School of Law. Yes, give a big congratulations. And the prize money is 11,000. Now it's a time for Best Mooter. Yes, we know many participants are there and speakers, those who present from for semi-final round, final round. And I know we are very appreciative to each and every speakers, speaker one, speaker two from all colleges. So it's the time for announcing Best Mooter for the fourth DYPLC Moot Court competition. And the award goes to DYPLC team code. Any guesses? DYPLC team code 09 Dhruti from GNLU. Best Mooter Award. And the prize money is 11,000. Once again, congratulations. Now, please, it's the time for the second runner-up award. And the second runner-up award goes to DYPLC team code 35 Army Law College, Pune. And the prize money is 21,000 award. Congratulations, team DYPLC 35 Army Law College. Now, again, I know many participants are there. They are waiting and thinking about who will be the winner and first runner-up. So, I'm going to announce the winner of the fourth DYPLC. After that, first runner-up. So, the winner of the fourth DYPLC Moot Court competition goes to DYPLC 09 GNLU Gujarat. And the prize money is 51,000. And first runner-up is DYPLC 19 UMLA Mumbai. And the prize money is 31,000. So please give a big applause of all participants and winners, and many congratulations to all these teams. So congratulations to all winners and participants for their outstanding performance. May this experience add value to your legal journey ahead. And once again, thank you all for being part of this remarkable event. So congratulations to all. Vote of thanks. Is there anything to? Respected dignitaries, esteemed judges, faculty members, participants, and dear audience, my students, volunteers, and all. Myself, Dr. Vijeta Chaudhary, Assistant Professor from Dr. D.Y. Patil Law College. As we conclude this remarkable fourth DYPLC National Moot Court competition, it is my privilege and honor to extend a heartfelt vote of thanks to everyone who contributed in making this event a grand success. On the behalf of Dr. D.Y. Patil Law College, we express our sincere gratitude to our chief guest, Honorable Mahendra K. Mahajan sir, Principal District and Session Judge, who graced our inauguration ceremony with their presence and inspiring words. Your valuable insights on legal advocacy and jurisprudence have truly set the tone for this competition. So I give a big thank to Chief Guest Honorable Mahendra K. Mahajan sir. We extend our appreciation to the preliminary round judges whose keen evaluation ensured a fair and competitive start to the event. Our gratitude also goes to the advanced round judges who further challenged our participants with complex legal arguments, helping them refine their advocacy skills. So, once again, I give a big thank to the judges from preliminary round judges. The semi-final rounds witnessed intense legal battles, and we are very grateful to our distinguished panel of judges who guided and evaluated our mooters with patience and expertise. A special thanks to all participants who demonstrated outstanding sportsmanship. A special word of thanks to the final round judges, Dr. Sarupa Dholam ma'am, who dedicatedly their time to critically analyzing the arguments and provided invaluable feedback. Your expertise has been an enriching experience for all. We also extend our gratitude to our finalists who have set an inspiring benchmark with their advocacy skills. A huge thanks to our management for their kind support and cooperation. I would also like to appreciate our beloved principal, Dr. S.S. Gopakumar sir, for their inspiring and cooperation in conducting these type of events and competitions. So again, I give a big thank. We are also indebted to our sponsors, Randive and Randive Associates and Ramkrishna Law Firm and Legal Tech Partners, Manupatra, Media Partners, Law Octopus, Law Bhumi, and Knowledge Partner, Law Octopus Law School for their support and the generous contribution that made this event possible. I'm also thankful to my faculty coordinator, Assistant Professor Deepali Shitore ma'am, Assistant Professor Sagar Verma sir, Assistant Professor Samruddhi Shah ma'am, who extended their support to me during the entire event and also to organizing committee, registration committee, technical committee, coordinating committee, result committee, food committee, hospitality committee, and student committee. So I give a big thanks to all these committee and committee members and volunteers. Special recognition to our committee conveners, Ms. Ritu Singh, and co-convener, Mr. Shantanu, Ms. Anjali Rai, Ms. Nivedita Roy, Mr. Rohan Lokhande, team head, Ms. Neelanjana Bose, Mr. Satyam Kumar, Mr. Abhijit Kumar, Mr. Rohan Deshmukh, Mr. Gautam Patel, Ms. Mehak Shroff, Ms. Sejal Ghotapade, Ms. Isha Patel, Mr. Aryan Raj, and all other Moot Court committee members who have worked tirelessly day and night on and off camera from past few months. So once again, I give a big thanks to all these committee heads and volunteers. There are many volunteers. I cannot take the name because more than 40 volunteers, they are working last 2 months. So again, I give a big appreciate to these volunteers. Thank you. Last but not least, to all our participants,
whether you won or not, but your passion and commitment to this event have been commendable and also to our audience. Your enthusiasm and support have made this event even more special. With that, we bring this incredible journey to a close, hoping that this fourth DYPLC National Moot Court competition has been a stepping stone for many aspiring legal professionals. So thank you. Thank you once again to all faculty members, teaching, non-teaching. Once again, I give a big thank to our management, all judges from all rounds. And I know it's a time like 9:20, 9:40 time. So again, I'm not going to take much more time. So thank you once again, and we look forward to seeing you again in future editions. So thank you so much. Thank you.
Thank you very much.
I request all faculty members, all volunteers, student head, committee heads, please come down. We have take a group photo. So please, everyone, please gather first floor.